In this video, we would like to discuss all other rest fields to which Article 41 right to equality was or is applied. So, regarding that, the first one is regarding statutory rights. So, in this connection, we would like to discuss one important leading case, Raju Prasad Sharma versus State of Assam in 2015, decided by the Supreme Court. So, in regards to that, the Supreme Court expressed that where the right stands established under Article 14, the court shall have no difficulties in enforcing such right, whether it is statutory or fundamental or constitutional right. And the next field that we will discuss, that is regarding flexibility, and in connection to flexibility we will discuss one important leading case, that is premium granites versus state of Tamil Nadu in 1994. The Supreme Court has expressed Article 14 has an inbuilt built flexibility to allow reasonable classification passed on an objective basis. And now we'll discuss another factor of legal ingredients in determining the scope and jurisdiction of Article 14 is regarding equal citizens. So, in regards to that, we would like to discuss one leading case, that is Bhagwan Das versus Punjab State Electricity Board, and the year was 2008, and it was decided by the Supreme Court. And in its expression, Supreme Court expressed that the superiors of disabled employees are duty bound to follow law, and it is not open to them to allow their bias to defeat their lawful rights. What the law permits to them is no charity, but their right as equal citizens of the country. And now we'll go to the next one, and that is relating to executive actions. And in relation to executive actions, we would like to discuss a leading case, Suman Gupta versus State of Jammu and Kashmir, and it was decided by our Supreme Court in 1983, where it was expressed that occasionally administrative action which violates equality comes up for scrutiny before the courts. Such action may be based on statute or may be purely executive action of an administrative nature, that is of non-statutory character. In either case, a statutory or non-statutory order of the executive which is arbitrary may be set aside. So, this was the very decision of the Supreme Court in relation to Suman Gupta versus State of Assam. And now we'll go to the next field, that is regarding classification. And in relation to classification, we would like to discuss the decisions of two important leading cases. One is Nandini Sundar versus State of Chhattisgarh, and a case of 2011, and it was decided by Supreme Court. And in the same way, we will discuss another leading case, Transport and Dock Workers Union versus Mumbai Port Trust, and it was also a case of 2011 and decided by the Supreme Court. And in the following case, it was expressed that if a classification is conducive to the functioning of modern society, it would be certainly reasonable and rational and not violative of Article 14. And in the very case that relating to Nandini Sundar versus State of Chhattisgarh, it expressed why their lordship, the industries which have few requirement use of water, they are placed as one distinct category or class of their own and are also differentially situated from residential houses. There exists an intelligible differentia as it was decided by their lordship. And the next one, that is the field regarding newspapers. And in that connection, we would like to decide one important leading case, and that is Hindustan Times versus State of Uttar Pradesh, and it was decided in 2003 by the Supreme Court. So there it was pronounced the state cannot, in view of the equality doctrine contained in Article 14 of the Constitution of India, resort to the theory of take it or leave it, the bargaining power of the state and the newspaper in matters of release of advertisement is unequal. Any unjust condition thrust upon by the state would attract the very worth of Article 14 as it was decided by their lordship. And in our next important leading case, and that is regarding state giving telegraph license, and in that regard we would like to discuss the most important leading case in relation to telegraph license is that Bharati Airtel Limited versus Union of India in 2015. The very pronouncement was that the distribution of license is subject to provisions of Article 14 of the Constitution of India, and such distribution must not be on the basis of some rational policy. The obligation of government follows the Constitution as well as law. And the last and the next one, that is relating to an landmark outstanding case relating to the constitutionality of Section 377 of Indian Penal Code was questioned in this leading case, Navtej Singh Johar versus Union of India in 2018 by the Supreme Court. So, in this leading case, Supreme Court struck down Section 377 of Indian Penal Code insofar as it criminalizes consensual sexual acts between competent adults in private space. The Supreme Court observed that an examination of Section 377 of Indian Penal Code on the context of Article 14 of the Constitution revealed that the classification adopted under the said Section 377 had no reasonable nexus with its objects on as other penal provisions such as Section 375 of Indian Penal Code and the POSCO Act already penalized non-consensual carnal intercourse. The Supreme Court held that Section 377 of Indian Penal Code in its present form has resulted in an unwanted collateral effect whereby even consensual sexual acts by the LGBTs community have been woefully targeted, thereby resulting in discrimination and unequal treatment to the LGBT community. And the last one, in relation to that, regarding the very application of Article 14, will go to the very limitations that was declared by the Supreme Court in the very important leading cases. One is State of Rajasthan versus Vidyavati in 1962, and another one is Kasturi Lal versus State of Uttar Pradesh in 1965. So, as it was expressed, broadly speaking, judicial decision interpreting Article 14 while recognizing the paramount nature of fundamental rights recognize the need on consideration of reality to have certain limitations. It is often stated that equality before the law guaranteed by the first part of Article 14 is a negative concept, while the second part is more positive concept. Neither part of the article is above the recognition of exceptions and qualifications on special grounds. Thus, while the first part, which is mentioned by Dicey in his Law of the Constitution, as a second corollary of the rule of law, would rule out any special privilege for any authority or person, but Constitution does not give certain privileges to the president and the governors and also a member of parliament and state legislature. Moreover, some of the provisions as interpreted result in a certain element of discrimination. For example, the liability of the state in tort, even today in India, not necessarily the same as the liability of any private employer. According to the current theory, no suit lies against the government for an injury in the course of exercise of sovereign function of the government, and as to trace its very history of state liability under tort, we could here mention the particular important case that we found in pre-independent India, and it was a case of the first one against the British Emperor, and the very case was the Oriental Steam Navigation versus the Secretary of State of India, where Lord Justice, Chief Justice Peacock of Calcutta High Court expressed that there the state was liable as it was performing some non-sovereign function. So, for the first time, Chief Justice Peacock made a difference between sovereign functions of the state and the non-sovereign function of the state. So when the state and its officials or servants, they are performing certain non-sovereign functions, they would be held strictly liable. So also there, as servants and officials of the state, are vicariously liable under law tort. So, this is all about the application of Article 14 relating to right to equality. So, in both the aspect equality before law and equal protection of law, as it was a legal ingredient we analyzed in our previous videos in relation to their scope and jurisdiction, how it were determined by our judiciary, either in case of the apex court or Supreme Court and all other high courts in India, and as relating to its applicability in relation to different fields. Already also we have finished one previous video regarding the very applicability of the very scope of Article 14 relating to right to equality and equality before law, and lastly the very limitations of Article 14 in relation to state liability under law tort, and in that connection we have discussed the very views expressed by the Supreme Court in relation to State of Rajasthan versus Vidyavati in 1962 and Kasturilal versus State of Uttar Pradesh in 1965, and also the pre-independent and the first one of the first most important case against the British Emperor, and that was Oriental Steam Navigation versus Secretary of the State of India, as it was decided by the then Chief Justice Peacock of the Calcutta High Court in determining the very liability of state under law tort, and in that very decision he defined the very sovereign and non-sovereign functions of the state, and when state or its officials or servants were performing non-sovereign functions, then the state would be held liable under law tort.